Hello, and welcome to another U.S. Tech Workers podcast. I'm your host, Kevin Lynn, and I am joined by attorney John Miano. And today we're doing this podcast as a recap of today's events. Today, John had his day in court in the Circuit Court of Appeals here in Washington, D.C. with his WashTec versus Department of Homeland Security. John, hello, and welcome to the show.
Hi, Kevin. Great to be here as always.
It is. It's always great to have you here, John. So, as I'd mentioned, today you had your day in court. After many years, we might actually get a clear decision that could impact programs such as the optional practical training program, and that could have implications for other employment authorization programs out there. John, what are your thoughts on how the day went?
Well, we hit a lot of technical gremlins. That made it a little bit exciting. But then, basically, there was three issues. The court seemed to be very concerned about standing, which is kind of surprising to me, given the state of the case and how far it's been along and how many times standing has been resolved already. So, in the previous appeal of this, there wasn't an issue of standing, and that seemed to be some of the things that the court wanted to talk about the most. And standing would basically allow the court to do yet another punt and push us down a road. So then we'd have to file yet another lawsuit in litigation that's been going on for nearly 14 years.
Wow. But do you think you got them over that hurdle today, John?
I think so. You look kind of ridiculous for to have this going on for so long. I guess I speak to the Senate staffers. They just scratch their head over this case of how this can go on and on and on. I don't think it can go down that way, but there's always that possibility, and that would be a really bizarre outcome and would stretch us on more, because then we'd have to file another case and do this standing thing over again. So the thing that's funny is that in these lawsuits for American workers, we spend more time fighting over standing to bring the lawsuit than the actual merits of the case. For example, in the Save Jobs USA case, we spent 5 years litigating standing alone. We're not talking about, we spent 5 years litigating whether we have the right to litigate. And we've spent a lot of time in this case just litigating whether we can litigate. And it's very frustrating because you see many other plaintiffs and people even intervening in this case where they just fly through the standing hurdle and no one even asks about it. So I hope that that this is while it's been rough in the standing, that it will go forward.
Explain to me, John. I know there's a couple things that you want to get, but I was there today. I was listening in, and there were opposing you referred to them as interveners. Explain how they get standing in a case like this.
Well, what happened during the Trump administration, apparently big business thought that Trump might take a dive in the case, which they obviously didn't do. And so they intervened to defend the rule, the OPT program. That's something that the federal rules allow, is that if you have an interest in some issue in the case that's fairly substantial, then you can intervene. But intervene requires having standing, just like that. And the big business had absolutely no problem with standing. No one questioned it. And also in the Save Jobs USA case involving employment on H-4 visas, we had H-4 workers intervene, and they just flew through the standing, without any question. While we're litigating standing for 5 years to get
right. Whose jobs were actually impacted and livelihoods impacted by it.
Right. So I said, I hope it'll go, but again, it's very frustrating to see how the courts put such scrutiny to ordinary American citizens to gain access to the courts of their own country. I mean, it's, I find it rather disturbing, and especially since these are this is the juror pool, essentially, the guys that are going to be filling the seats, and I would think that they would be more anxious to reach out to them. But that, again, that's my great disappointment since joining the law. And it's not just here. I mean, it's all over. I mean, anytime workers who've been displaced by H-1B workers try to bring a lawsuit, they can't get a bone from the courts. We had the discrimination case out in San Francisco, and the courts were excluding, highly information that really would have made the cases, so the juries weren't seeing it. So I think that this is a common thing that when I speak to other lawyers who represent just ordinary Americans, not any special, that they don't seem to get a lot of respect. I don't feel like they're getting a lot of respect. Now, that could be changed, but and I'm not talking about outcomes here. Things can come out well, but the amount of effort it takes is just inordinate just to be able to have your day in court.
Right. But you did have your day in court, and even though you had to spend a lot of time defending your standing and the standing of the plaintiffs, they did allow you to present your oral arguments. So how did that go?
Well, that seemed to go pretty well. I mean, the thing that happened in the district court is the district court came up with held that the student visa, which is for bona fide students solely pursuing a course of study at an approved academic institution, that Congress's definition of a student visa only specifies entry requirements, and that as soon as someone enters, DHS can flip and just let them do whatever they want, right? Which is, striking holding, because if it were applied to other visas, basically nullify the requirements of any visa. And in particular, if you look at the student visa, this holding totally nullifies the entire visa because it's not being applied at entry. So in theory, they're saying, how to put this, that everyone's saying we need this program to allow aliens to work on student visas when they're no longer students to track students. Okay? But then they're saying, but when these people come to the United States, no one is saying, are you coming to take this program, to take advantage of this program that allows you to work? Because if you do, you're not eligible for this visa. So that restriction is not being applied at entry. It's not being applied post-entry. So it's basically a legal fiction to allow DHS to completely ignore the statute. And I said, if that happens to other visas, and American workers are just totally screwed. Because here, like in the case of the student, that visa is that F1 visa is granted solely for them to be a student. That's what Congress was intended to happen and instructed to happen. But DHS seems to have, as you're saying, other ideas. Yeah. Well, DHS is allowing these aliens now to work for up to 42 months in the United States after they graduate to provide labor. And this is something that Microsoft did. Maybe we'd go to the history here, is that in 2007, Microsoft had took part in a dinner party for the DHS secretary that was Chertoff at the time, and it was thrown at the home of the billionaire owner of the Washington Nationals. And Microsoft pitched the idea of taking the existing OPT program that allowed a year of work after graduation. And, when it was a year of work, short thing, no one was suing over it, even though it was technically illegal. It wasn't worth 14 years of litigation we've gone through already. But Microsoft then told DHS that they should extend it to 29 months, by 17 months to 29 months. And then DHS took Microsoft's thing and idea, worked with lobbyists in total secrecy. And DHS didn't even say, we're doing this rule. Anyone who's interested, tell us about it. They only worked with industry and academic lobbyists, put the rule, and then threw it out without notice and comment. So we're basically opening, if the courts were to adopt this thing, this is an entry requirement, then we're basically setting the system that Microsoft then can just get whatever it wants by throwing a dinner party to the DHS secretary.
Wow.
And the really scary thing is, if you look in the immigration system, we have places where Congress directly authorizes alien employment. They'll say, if you come on this visa, you can get work. Congress also enacts provisions that say, DHS, you can, by regulation, you have the discretion to allow this group of aliens, or, and sometimes they say it's mandatory. Okay, so there's basically two ways the statutes authorize it. And then in addition, DHS has created this system where they just offer alien employment without Congress telling them to. Okay. Now that regulations without Congress there are more aliens coming into the workforce every year under that type of regulation than are authorized by Congress or regulations authorized by Congress.
You would think every member of Congress would be up in arms, but then again, Congress has pretty much acquiesced its power to make war, and pretty much given that over to POTUS. If you look at what happened in recent history, so another place where Congress appears to be abdicating its authority and power.
And it's particularly ironic because this was a deliberate attempt to undermine what Congress had enacted, what Microsoft was doing. It was to get around the quotas on H-1B. But Congress, right now, what's Congress? They're trying to spend $3 billion on whatever, without a plan, whatever we throw $3 billion and call it an infrastructure bill. Congress, enacts legislation to regulate toilets. Basically, Congress has gotten into so many things, it doesn't regulate the things that it's constitutionally mandated to regulate at this point. And so, the country, we basically created this separate government that where most of the laws in the country now come from the bureaucrats. They don't come from Congress. Most law now comes from this system of regulation, and the public doesn't have access to this. Because these people aren't elected. These are the theory is that these are professionals who would be there and have their expertise in these areas. In reality, they're guys who are preparing for their lobbying job when they get out, when the administration changes. So they have every incentive to cooperate with big money, and that's basically what has happened.
But it seemed that you were able to pretty much shoot down the arguments of the interveners. You seem to have a pretty good discussion with the judges on the merits. There were a lot of questions asked. What do you think the prospects are, John? And what are the next steps, and what do you think the prospects are?
Well, next steps are wait for the opinion to come out, which usually takes about two months, maybe 3 months. My greatest fear is that the court will say this is too tough a decision, so we'll punt on standing, and this drags out for another 5, 6 years. Because we're prepared, as to bring yet another lawsuit, because if they dismiss it on standing, it doesn't have the merits, and that's why this thing keeps on going. So if they dismiss it on standing, there's going to be guaranteed there's going to be another lawsuit, and this is just going to keep going and be an embarrassment for the courts that they can't decide. But that's my great fear. Then my next, then you have the question of the merits, whether they could. I don't think that they'll actually adopt this entry requirement thing that the district court came up with, because just unleash havoc in the immigration system because then DHS could do whatever it wanted on any visa. So although there's a lot of discussion on that, I don't think they'll go there. But another great fear is they come up with something we haven't thought of, to come up with the answer, and hasn't been discussed yet, which has been known to happen. And of course, the greatest thing is that the court says, DHS, you got to follow the law, and that's what the statute. The statute says that It's got to be a bona fide student solely pursuing a course of study at an approved academic institution. What does solely mean? So, and the law is pretty straightforward. Anyone can go out and look it up, and I don't think most people who would read that statute would come away from it saying, oh, it allows DHS to permit aliens to stay in student visa status for years after they graduate so that Microsoft can get cheap foreign programmers.
Well, well, I'll tell you something, John. I think you did a great job today. Right out of the gate, I think you responded well to the questions and comments of the judges. I think you did a much better job than the interveners. The one guy, I believe, was from the National Association of Manufacturing and some tech interests, and there are a couple other people there. But you took them all on, and I believe you're going to prevail, John. And I believe that when you prevail, the OPT program is going to get thrown out completely, and it's going to be a boon for American tech workers and STEM workers, but a boon for the families that have invested heavily in their kids' education and find that they're not getting jobs in these well-paying fields when they graduate. So I think you're going to win, John. I think you did a great job today.
Well, thanks for the vote of confidence. But the other thing to win would happen would put the brakes on things getting worse. Things have been getting worse and worse and worse in this over the past years. This is why ordinary Americans haven't seen a pay raise since 1970.
Absolutely.
One of the reasons is we have just through regulations bringing more and more foreign workers, and these workers are frequently used to displace Americans.
Absolutely. John, is there anything else that you would like to share with our audience on what happened today?
It seems like we got it pretty much covered, except we mentioned the technical problems that plagued us.
Well, you got, there was some technical problems initially, and you got cut off at one point. You're
2 points.
And you're doing this broadcast from your home office, which is a bit of a war zone with the flooding.
Yes. My office here is going to be demolished starting on Saturday because it's been flooded.
Wow. Well, as the adage goes, one wheel on our wagon, and we're still rolling along.
Yeah.
Well, John, on behalf of all tech workers, all STEM workers, Americans, I want to thank you for the years of service that you put in. It's grueling, but from what I saw today, you're probably the most knowledgeable legal mind in this area, and I gotta believe we're going to prevail. And when I think of how close we were with the Trump administration, when they had put out those 3 rule changes for H-1B, and had things gone differently, they would have had, and they all had been enacted, we'd have pretty much defanged the H-1B program to the point where it would no longer be a threat to American workers. And if we would have gotten that plus OPT, heck of a thing. But we'll get there, John. We're not going to stop like you. We're not going to stop fighting.
Well, thanks, and we'll always thank you because you've contributed a lot as well. You were one of the biggest leaders in the fight here, and I'm not sure people know all the stuff that you're involved with to keep the fight up here against this, the displacement of ordinary American workers.
Well, I'll tell you, I'm blessed with a great staff. Roger Ross, Maria Corvo, Maria Fotopoulos, Denise, Joe Gazzardi. We're blessed. We're an amazingly small staff, but we've been able to do great things. I think largely because we're motivated and we have great relationships out there with the community. So,
we're on a mission from God.
Yes, yeah, exactly. We're the Blues Brothers. Yeah. To our audience, I just want to say, if you enjoyed this video, please give it a thumbs up because that always helps with the algorithm and getting us placed. There are a lot of people that seem to think that we're being shadow banned out there by the powers that be, and those thumbs up certainly help with that algorithm. And by all means, go to visit our website, ustechworkers.com, hit that donate button, because it's those donations that help us stay in the fight here and be effective. Again, John, thanks a lot, and signing off.
Bye.